Please join us for this webinar. Feature two distinguished professors of law, Jonathan Turley as well as Michael McConnell, speaking about religious freedom and First Amendment rights, discussing some cases that are before the U.S. Supreme Court that will affect your religious rights in our state. Good afternoon. My name is William Harrison. I'm the president of the Christian Legal Society Hawaii chapter, and I'm privileged to welcome you to this webinar titled First Amendment Crisis or Progress. Today we'll discuss several recent court decisions that have a direct impact on the exercise of our religious freedoms. I'm thrilled to introduce today's distinguished speakers. Professor Michael W. McConnell is a senior fellow at Stanford University, Hoover Institution, the Francis and Richard Mallory Professor of Law and the Executive Director of the Stanford Constitutional Law Center. Before moving to his present position in 2009, he sat as a circuit court judge on the United States Court of Appeals for the 10th Circuit. Aloha and welcome, Professor McConnell. Professor Jonathan Turley joined the George Washington faculty in 1990, and in 1998 was given the prestigious Shapiro Chair for Public Interest Law, the youngest chair professor in the school's history. Professor Turley has served as counsel in some of the most notable cases in the last 2 decades, which included the representation of whistleblowers, military personnel, former cabinet members, judges, and members of Congress. And also welcome and aloha, Professor Turley.
Thank you.
So before we begin, I'd like to begin our time in prayer. So please join me in prayer. Heavenly Father, may you bless this webinar, the fellowship, and our time together. We pray that there be no technical difficulties. We ask that you provide all of our participants and viewers wisdom, guidance, and discernment, and that you open our minds and hearts to the proper message that we should receive. We pray this in Jesus' name. Amen. Let me start this off with an introduction. There's a clear tension in our society today between those in our community which advocate for anti-discrimination laws and those which seek the free exercise of their religion. How do we reconcile these compelling First Amendment rights? Is there a way to resolve the tension between discrimination laws and freedom of religion? We're hoping that the recent Supreme Court cases, Cake Shop, Fulton, and Americans for Prosperity would help to do so, and tell us whether Employment Division versus Smith is still valid, but have they? Let me first turn to Professor Turley. Can you briefly set forth the background of the facts in the Cake Shop case? What are the issues, the court's ultimate decision, your view of the decision, and implications on religious freedoms?
Well, thank you very much, Bill. It's a great pleasure to be here with you, with Michael. You know, after this long and painful process of the pandemic, I thought I had seen every soul-crushing aspect until I was invited to speak at an event in Hawaii from my home. So that may be a new low for me. So I want to thank you for that. Masterpiece Cake Shop is actually a fascinating case, not only because of its trajectory, but also its ongoing litigation. It also shows how the court has a remarkable ability to find exit ramp. Of course, Masterpiece Cake Shop, as many people know, involved a cake shop in Colorado by Jake Phillips, who was asked to do a cake to commemorate an earlier wedding in Massachusetts by Charlie Craig and David Mullins. This was viewed by Phillips as contradicting his religious beliefs, and he declined. That ended up becoming a case under the Colorado Anti-Discrimination Act, which includes prohibition on discrimination based on sexual orientation. And the Colorado Civil Rights Division referred the case to the commission, which ruled against Phillips. So this ultimately gets to the Supreme Court, and the Supreme Court actually punts. It doesn't deal with this case issue that many of us have been waiting for a very long time. Over 10 years earlier, I'd written an academic piece about the inevitable collision between discrimination laws and the religion clauses. And so this was really the perfect case for that issue. But a 7-justice majority formed around this view as stated by Chief Justice Roberts by Kennedy, that the case had to be remanded because of the demonstrated hostility shown by the commission to religion. And that allowed them to essentially avoid these knotty issues. It was quite a buzzkill for most people that were waiting for this decision. It was like Brown v. Board of Education coming down as a remand based on improper class certification. I mean, it was this was going to be the case that answered all those questions. There was also another case that might have done that, and that's Arlene's Flowers versus Washington, but that was also remanded. So one of the big issues, of course, which is overlapping with this case and with the Fulton case, is the gravitational pull of cases like Smith and the test to be applied, whether this is a matter of the religion clauses or whether it should be, according to some of us, approached from a free speech perspective. That free speech perspective was in fact stated in the case in the opinion by Thomas and Gorsuch, who raised speech as the issue that is most pressing here. Also, Gorsuch wrote as a concurrence that addressed this as well. So Arlene's Flowers was ultimately remanded, and it came back up. Now, the person there, Stutzman, actually added a religious hostility claim after the Masterpiece Cake Shop decision, and that went back down. She lost and went back to the Supreme Court, and many people thought maybe the court would now take the case. It did not. As many of you know, this month the court declined certiorari. And so the final opportunity to the present day that we saw for this to be addressed was again sent asunder. Now, however, we have a new Masterpiece Cake Shop case. This is a manufactured case. So the cake that was requested was done by an advocate who was trying to essentially relitigate the original case. And so we now have a case called Scardina versus Masterpiece Cake Shop. Phillips again was found to be in violation of the anti-discrimination law, and it's heading its way back through the federal courts. And part of the issue that many of us are hoping the court will finally bring clarity to is not just how to deal with this conflict between discrimination laws and the religion clauses, but also how this should be framed. I've never been particularly comfortable with treating this under the religion clauses. To me, this is more of an issue of free speech. That, you know, I would feel the same way about neo-Nazis coming into a Jewish baker and saying we want a Mein Kampf cake, or the KKK going to an African-American baker and saying that we want a white supremacist cake. The question is, do they have to do that? Or is there an element of speech? Now, of course, if you take the speech route, we're really focusing on the expressive aspect of cakes. So that would naturally encompass certain types of functions, but not others, right? So that a florist, like we saw in the sister case, or a baker or a photographer are doing expressive acts. Phillips actually said that he would sell any cake to any person in this as a public accommodation. He just would not prepare a cake that celebrated or memorialized a same-sex marriage or union. So the court then, in my view, has a cleaner approach if it deals with this as a speech matter, because it really gets us out of some of these knotty questions. It doesn't get us out entirely, because there is no easy answer here. I mean, there's really good arguments on all the sides here. People are trying to grapple their way to try to find terra firma in these cases. But in my view, the free speech cases offer the best avenue for addressing it. Otherwise, I can't see how we're going to thread this needle. I mean, both sides are using slippery slope arguments, and that's perfectly legitimate in my view. But to me, the more chilling future is if people who have businesses cannot rely on their religious views in order to decline certain contracts or jobs. And to me, I think this is an area where you can have accommodation for religion. But the other thing is that there's other issues beyond religion, as I gave those earlier examples, where I don't think it's fair to require people to make cakes that have expressive elements that deeply contradict their views. And so whether the court will accept this is a really good question. We've seen now 3 chances at the plate in really quick succession where the court decided not to take it. But, you know, the court tends to be conservative, particularly institutionalists like Chief Justice Roberts, in taking some of these cases. They look for the right case. They obviously are tacticians, so they look to make sure they have the votes to support what they're doing here. From the oral argument in the case, it seems like they do have sufficient support for coming up with a more clear opinion on how to handle this. Moreover, this is really the conflict of our generation. This is happening all over the country, these conflicts between anti-discrimination rules and religion clauses. And that's borne out in the recent case of Fulton, which I believe Michael is about to address. So why don't I stop there to make sure we have enough time if you want to go to Fultonville.
May I just say something about the Masterpiece case?
Absolutely. Yes.
Is the underlying problem here is that anti-discrimination law has been redefined to mean something other than discriminating against people because of their protected status. You know, imagine, 30 years ago that you had a baker or a florist who served African-American customers all, freely for everything, but did not agree with the NAACP, and he was asked to bake a cake or, whatever it happens to be for an NAACP meeting. And he said, sorry, I don't like that organization. I'm not going to support it. No one would have said that he was discriminating on the basis of race. Well, that's all Mr. Phillips did here. He does not discriminate on the basis of his customers' sexuality. He simply did not want to give his services to an expressive occasion, to a meeting, a ceremony that he did not approve of. The problem is that should never have been defined as falling within the scope of the discrimination laws to begin with. It's only because of that these cases are coming along. I just do not believe that there is any fundamental conflict between the First Amendment and the Equal Protection Clause or anti-discrimination law. What there is a conflict between the First Amendment and this idea that anti-discrimination laws can be used to force people to participate in or express approval of occasions or events that they disagree with. It's simply a mistake.
So Phillips did not, what you're saying basically is Phillips did not condone that belief and chose that he chose under the circumstances not to advocate through his baking of the cake. That belief is basically what you're saying, right? So
exactly. He did not discriminate against the customers because of who they were or because of their being gay or their being a same-sex couple. or anything of the sort. He simply does not approve of the wedding ceremony, and he did not want to participate in it.
Okay, so that segues quite nicely into the Fulton case, and people were expecting that we would see a different composition, and we'd see a different, or at least a more broadened approach to this issue. So, Professor McConnell, can you delve into the Fulton case and talk to us about what the court did in that case, and give us a little bit about the background of that case?
Well, I can try. This is a case involving Catholic Social Services, which has been in the adoption and orphanage and foster care business for literally hundreds of years in Philadelphia. And recently, after an article in the newspaper about another foster care agency, the city came to Catholic Social Services and said, would you certify a couple as foster parents if they are either not married, so heterosexual unmarried couple, or a homosexual same-sex couple? And they said, no, we if that happened, we would refer them to another agency. And the city decided that violated their anti-discrimination policy, and the Catholic Social Services, not surprisingly, asserted the free exercise clause as a defense on the ground that as a Catholic social agency, they should not be required to conduct their activities in a way which is in violation of their religion. Now, they come against a rule from a 1990 Supreme Court case, Employment Division versus Smith, which had to do with the use of peyote in Native American religious ceremonies. And in a 6-3 decision, it's really 5-4 if you squint, but divided decision in any event, the court held for the first time and in violation of its precedents, and with no analysis of text or history, it was really a remarkable decision. They held that the free exercise clause does not provide any protection against laws that are, quote, neutral or generally applicable. In other words, they changed the free exercise clause, which is part of the First Amendment, from being a protection of a particular freedom into being a kind of junior league limited equal protection clause for religion. Well, this was greeted by, this is with great gnashing of teeth and wailing across the spectrum. And, Congress even passed a law, if you can believe it, unanimously in the House of Representatives, and only 2 dissenting votes in the Senate against this position. Everybody, left, right, and center, thought that this was a terrible thing. The dissenters in the case were Justice Brennan, Justice Thurgood Marshall, and Harry Blackmun. So, and Justice O'Connor is the other whom I think should be counted as a dissenter. So it was the liberals on the court that thought this was very bad. It was shrinking of civil liberties, and since then, it has not gotten any better, and yet Justice Scalia, the author of the opinion, was just a fervent supporter, and he defended it. But now that he is gone, I think most people think that maybe the court will reconsider this. But on the other hand, this court is very, as you pointed out, Bill, the court is quite cautious. They do not want to have to overrule any more cases than is absolutely necessary. And so when they looked at the Philadelphia rule, it turns out that there is no generally applicable prohibition here, that the city had complete discretion to exempt any of these foster care agencies from the discrimination laws, in any case at their sole discretion. And the reason for this ought to be pretty obvious. It's because I think there's something, 36, I may have the number wrong, foster care agencies operating in Philadelphia. Most of them cater to some particular subsegment of the population. So you have some that specialize in Native Americans. You have some that specialize in this and that, handicapped children, and so forth. And technically, almost any of them discriminate in one way or another. And so, of course, they're not going to apply anti-discrimination laws across the board. It would be the system as a whole is non-discriminatory. It's just that different agencies specialize in servicing different subparts of the client base. And so when you look at it that way, Catholic Social Services did not violate a neutral law of general applicability. They felt they violated a general rule that's subject to discretionary exceptions, and that turns out to violate the Free Exercise Clause even under Employment Division versus Smith. So I think it's not surprising that the court refrained from taking the logical step of reconsidering Smith and simply unanimously held for Catholic Social Services on this narrower ground.
Well, would you say it's easy to make that determination if we're going to narrow the scope of this, right? And everyone was waiting for that bigger decision, that broader decision to really cement the line here as to where we can go with our religious freedoms, or on the other hand, with our individual rights, correct? So how does that affect and does it affect, and where's the court going with this recent decision on Americans for Prosperity Foundation? Can I ask Professor Turley to start that conversation off, and then ask Professor McConnell to weigh in as well?
Yeah, I mean, first of all, I would note that one of the interesting aspects about Fulton, if I could just make one comment about
Sure.
that, you have 5 to 6, depending on how you count them, justices that had some fairly direct statements about Smith as not conforming with their view of the interpretation of the Constitution. Justice Barrett said basically it reduces the protection to an anti-discrimination rule as opposed to protection for free exercise. So this is an interesting case where you have such a strong majority coming together and basically saying, we do plan, or we do view Smith as dubious, and in some cases outright invalid. So this is not one of those tea leaf type of cases where you have to sit around and say, what do they mean by this? It's very strong language that is, I'm sure, encouraging dozens of cases to try to be framed to get back to the court to snatch that up. The other thing I wanted just to mention, even though we're talking about Supreme Court cases, is that we just had a decision out of the Eighth Circuit, which is an interesting comparison. This is the business leaders in Christ versus the University of Iowa. This is the second decision against the University of Iowa, which imposed an anti-discrimination rule under their human rights provision at the university that required this Christian group to drop their demand that leaders adhere to their Christian values. So the group had said, we will accept anyone as a member. So that's why it's sort of an interesting analogy to Mashpee's Cake Shop. So we'll accept anyone as a member, but if you want to be an officer, you have to agree to follow these Christian principles. And the University of Iowa came down and decertified them. And they went to the Eighth Circuit, and the Eighth Circuit said, look, this is religious discrimination. You can't do this. Iowa then, after that decision, and that also involved immunity for the school, when it came up a second time, the Eighth Circuit was in a foul mood and said, wait, we just told you you can't discriminate. You turned around and you decertified another Christian group under the same principle. And also, your history shows that you've accommodated all these other groups that have exclusionary rules. There has to be a particular race, you have to be a particular gender identification, and yet just for these Christian groups, you come down and you decertify them. And so he says, they basically said no immunity because you're basically a recidivist as a university. So I just want to note that because that's a case that I was obviously continuing to litigate, and that could end up going up to the Supreme Court as well. Now we have, as you mentioned, Bill, we have these other cases, including Americans for Prosperity Foundation versus Bonta. And in that case, you had a case brought by the Thomas More, it was consolidated with the Thomas More Law Center. And it involves California's requirement that nonprofit organizations disclose the identity of their donors. And the court gave a very strong majority and said that that violates the First Amendment. And this is great for those of us who believe in the right of anonymity as well as an essential component to political speech. And then finally, the other case is the case which I'm not going to try to pronounce its name, but it's out of Georgia and involves a question of whether you have standing if you have sort of de minimis losses. This was a person who was trying to proselytize in a speech zone, and he was required to register. And the court ruled that he did have standing. This was an 8-1 decision and said, look, he has an injury, even though it's nominal in terms of direct cost. That case, to me, is huge because as a public interest lawyer, one of the problems I often have in going against the government is that they attack you on having concrete monetized types of damages. And if you're fighting for free speech or the freedom of religion, you're like, really? So I've got to try to find that I've got a few $100s of damage in order to litigate what is a foundational right that you denied to my client. So it's a very important case in that sense.
Yeah, and I think it's pronounced Uzu Egg Bunam versus Prishuski is the name of the case, I believe. And
I'll go with that.
Okay, Professor McConnell, I'd like you to weigh in on this discussion relative to these other cases that Professor Turley spoke about. How do we? And the question here, as we've all asked, is how viable is Smith now, and really will the Supreme Court actually address Smith at some point in time?
Oh, well, I think Smith is on its last legs, and the court will overrule it when there's a case that requires that, and I suspect that will be sooner rather than later. They just won't do it until they need to. Remember, a large majority of the court, 6 or 7 justices, I forget the numbers at different times, all wrote for many, many years that the Lemon test for interpreting the Establishment Clause, the other part of the religion clauses, was indefensible. And it was decades before the court really eventually got around to eliminating that, and it's not even 100% clear that they did it then. So, the court sometimes it leaves these old doctrines in place as long as they aren't doing a lot and any damage in the cases that they're actually hearing. I'm delighted that Professor Turley brought up the Eighth Circuit case and the Business Leaders for Christ case in this forum, because as the Christian Legal Society chapter, many of you of our audience may remember Christian Legal Society versus Martinez, a 2010 decision of the Supreme Court where I had the honor of representing the Christian Legal Society in the Supreme Court in a 5-4 loss that I regard not only as my own personal worst litigation moment, but I also think it was, and this is going to be a very strong statement, I think it was the biggest civil liberties catastrophe in the Supreme Court in the last several decades. And it's exactly the same facts as the Eighth Circuit Business Leaders for Christ case, but in the CLS case, which involved Hastings Law School in San Francisco, Hastings pretended that it had what it called an all-comers policy, which is to say they pretended that they had a neutral law of general applicability that required every single student organization to accept any student, no matter what, for leadership. Now, we showed on the record that there were at least 6 other organizations that required that their leadership share the beliefs of the organization, which is their right to do under freedom of association. But because the Hastings, claimed that it had this all-comers policy, the Supreme Court said, well, there's nothing more neutral than an all-comers policy. Everybody has to follow that, and it's okay. Well, it turns out that no university actually has an all-comers policy, so that although the Christian Legal Society lost in the Hastings case, similar organizations have been prevailing around the country, including in the Eighth Circuit case where Professor Turley is involved. And so for members of this organization should know that although we had this seemingly terrible setback 11 years ago, that as a practical matter, the right to have prayer meetings on campus led by somebody who believes in your religion and shares your prayers is now back on the table. I largely agree with what Professor Turley said about the Americans for Prosperity case, but I'd just like to comment on the commentary about it. I don't know how many times I read that this is just one more, right-wing thing supporting dark money and so forth. Look at the amicus briefs filed in that case, and you will find the NAACP, and I'm not sure I'm going to get all the organizations exactly right, but virtually every left-wing organization, along with virtually every right-wing organization in America, stood up in the court and said, hey, it matters for our members to be able to contribute anonymously, because any group can turn out to be controversial, and folks don't want to be hassled at work or fired from their jobs or mobbed the way has happened. In our current culture, where social media, Twitter mobs can be summoned forth at any, so easily, anonymity is absolutely essential for civil liberties to be a practical matter. And that is not a right-wing proposition. That is an across-the-board civil liberties proposition. So I think it is a great thing that the Supreme Court came out the way it did. Just footnote there too, the California pretends again to provide, to keep this information confidential, but the record in the case showed that the Attorney General's office in California regularly leaked this information when they didn't like the organization. So it had been the anonymity, supposed grants of confidentiality were weaponized by the government of California to go after their enemies. This is just a terrible thing. This is un-American. This is not something that should be tolerated. As to the unpronounceable case, I am very sympathetic to this group. It is the violation of the First Amendment rights in this case was blatant and intentional and obvious and repeated. But I just cannot. This is Chief Justice Roberts' first solo dissent, since he's been on the court for however many years it is now, long time. And he had a very good point, which is if we're going to have a mootness doctrine, which is to say that when a case is over and the government or the defendant has seen the error of their ways and has stopped doing it, right? And there were no past damages to collect to redress, there's no case left. Now, maybe we don't want to have a mootness doctrine or standing or any other limitations, but if we're going to have a mootness doctrine, it makes no sense, Chief Justice Roberts said, and I have to say, I think he's right. It makes no sense to say that the case is not moot if you ask for $1 nominal damages. The $1 is not it's meant to be nominal. That is, it's not damages at all. So I think either we should get rid of the mootness doctrine, or this case should have come out the other way. But we shouldn't allow tricks, just little lawyer devices like asking for $1 to be a get out of mootness free card. It's just irrational.
Yeah, this is on one point we disagree with. I think that Roberts deserved to be alone on that. And fortunately for Roberts, no one can pronounce the name of the case, so that might cut down citations. But they
can't spell it either.
But I do disagree. I must admit that Walter Dellinger once referred to me as a standing dove, and he's a standing hawk. So I certainly chafe at a lot of standing issues. I also chafe at mootness decisions. But this is why. When we're talking about constitutional rights of freedom of religion and free speech, it is, in my view, an artificiality that no matter what the damages may be to the denial of free speech in terms of some monetary measure, it doesn't come close to what the injury was. You're denied your right to pray, you're denied your right to speak. And then what happens is that these universities, the government constantly says, as soon as they're about to get to the Supreme Court or they're losing in court, they say, okay, we got rid of the rule. And we're not going to do that again. And of course, then they later do that. I just think it hasn't worked. And so, yeah, nominal damages are a bit of a trick, but they're not nearly, in my view, as artificial as requiring some monetary measure for something of far greater value, which was the denial of these rights. If they hit someone with a car, we wouldn't be really debating it in terms of, well, you've got ongoing damages to be paid for. But if they take away something far more valuable, like your right to worship or speak for a period of time, that's treated as sort of old news if they say that the foundational rule has been changed.
Okay, and when we talk about those nominal damages in a practical aspect, does that allow, once there's some nominal damages, does that allow for the plaintiff to seek payment of attorney's fees? And is that really something that really helps that individual cause, and also obviously puts the defendant on notice that you can't do this anymore?
Yes.
Yeah, it does. And I think Michael, in fairness to Michael, I commend him for noting that this is a bad case. The case really did involve really outrageous denials of free speech, really disingenuous responses, hostile responses from the university. They really played with this guy and with his counsel for a long time. And it sort of reminds me of that New York gun case where all of the New York City officials said, we're going to take this case all the way to the Supreme Court. This is a winner. And the minute the Supreme Court took it and it was clear they were going to lose, they pulled it. They changed the law and they said, now it's moot. And the Supreme Court chafed at that. There were some justices that said, you know what, we might not do that because this is getting out of control, that you make all these public promises that you're going to litigate this till the cows come home, and when we're about to rule, you then pull out of the case.
Okay, so moving on through these cases here, how do we really protect religious freedoms in this environment as well as protect individual rights? I mean, where do we go, and where is this court going to go to protect religious freedoms?
If I can just jump in here, the title of this program is, you asked the question, what it was, crisis or progress? I think is the way it's put. And it's actually both. It's crisis in our culture and progress in the courts.
Yeah.
Because our culture is taking a really dangerous turn toward intolerance of dissenting points of view. And we've been through, terrible periods of intolerance in the past, but this is at least in my adult lifetime, this is probably the worst I've ever seen, where the idea of live and let live seems to be completely forgotten. The idea, I remember when, all well-meaning students believed that we should be non-judgmental. Well, no more. I remember when there was a free speech movement at Berkeley of all places. It's really amazing to me how authoritarian our culture has become, and that at a time when also religious, the number of people who are practicing a religion is at a I don't know if it's an all-time low, but certainly a modern times low. And so out in the culture, there are more challenges and more crises involving freedom of speech and freedom of religion than I think we've seen in a long time. The courts can't do a lot about that because they just sort of they intervene only when cases are before them. But I think it is interesting that I think this Supreme Court has been remarkably consistent in its defense of civil liberties, and that's true not just of the conservative justices, but also most of the time of the liberal justices as well. It's remarkable how many religious freedom cases have been unanimous. And I like to say, when I was younger, conservatives tended to be the anti-civil liberties group, not always, but there was much more of a, the left really was the focal point of civil liberties agitation, and the right tended to be resistant. I'm happy to say that most of the right, not all of it, but a lot of the conservative mainstream right is now has joined the old liberal pack with respect to the importance of civil liberties. But unfortunately, the far left, not the normal sort of mainstream, your grandfather's, liberals, but the kind of identitarian left that's so powerful on campus and in the media and culture, that their interest in freedom of speech and civil liberties more generally has gone away.
Okay.
I would probably, I have a strong bias in favor of free speech as the framework for protecting rights, including religious exercise. I think that religious groups would fare better in a free speech framing of cases like Masterpiece, Cake Shop, because free speech has the most direct way of dealing with this and solving it. Because the classic idea, of course, is that the solution to bad speech is better speech, is more speech. And if you disagree with Mr. Phillips, you can condemn him. You can write articles, tell people you can boycott his cake shop. And then there's other people that are going to favor his cake shop. And then the marketplace of ideas and the actual marketplace will carry the day. What's also interesting is how conflicted many people are. Many of the same faculty that condemned Citizens United and the concept of corporate speech have suddenly embraced it with regard to social media, for example. I know that Michael and I will have some disagreement on that, but Michael and I agree, however, on the period of intolerance that we're in. I've litigated free speech cases for for almost 3 decades. I have to join Michael. I've never seen, nor did I ever imagine I would see, this level of intolerance I never thought I would see what's happening at universities, the level of intolerance from faculty. I get, because of my blog, I've gotten hundreds of emails from faculty around the country, and some based on religious objections, some on free speech objections, but they're terrified. I mean, they are real. They're silent because they're afraid that if they say anything, they'll be tagged and they'll lose their jobs. And it has happened. We chronicle a lot of that on the blog. I never thought we'd get to this spot, but I've never thought that faculty, for the most part, would be in such cringing silence. And that's what's so dangerous with this period.
Okay. So we've got about a little bit less than 15 minutes left, and I want to be able to give our viewers the opportunity to ask questions of both of you who have such a wealth of information in this area. So the question is, do you see a conflict between freedom of speech and the rules of bars, such as California requiring CLE on the prevention of bias in the profession? So I'm going to allow both of you to weigh in on this question.
Well, Michael, you're in California. You want to take a first bite, or?
Well, actually, I don't know the language of the rule and don't know exactly what it requires. But as long as a variety of organizations can put on CLEs from a variety of perspectives, I have no real problem with elimination of bias as being one of the topics.
Well, I think that the premise of the question is that there are some new mandatory requirements. Some law schools are moving towards a mandatory sort of race consciousness, anti-racism course as a condition for graduation. Some bars are considering that, and now there's a requirement that you actually have to take that CLE. You have to check that box in order to satisfy your requirements to the bar. And I initially sort of feel the same way Michael does, in the sense that I think that they can require that. I am uncomfortable with some of the material that I've read, which strikes me as going beyond the type of generalized training on legal issues that you have in CLE, and goes more into advocacy. But that's largely an objection that you make within the bar. I think courts tend to try to avoid micromanaging those types of issues.
Well, again, if a law school requires all students to take a course, and that course is propaganda, I think that is wrong. When the Soviet Union did that sort of thing, it was wrong, and for us to do that sort of thing is wrong. CLEs are usually structured rather differently. Christian Legal Society puts on CLEs, and as long as everybody can put them on, I'm sure Jonathan and I could organize a CLE on how to fight bias that would not be the same kind of propaganda that others would be. I do worry about it when the law schools, when they call it anti-racism, which I think is a misleading term, and it's one way of looking at this extremely controversial set of issues, that is wrong. Students should not be required, as a condition of becoming a lawyer, to sit through indoctrination.
Okay. Are both of you familiar with the movement across the country to put into play a professional rule that requires or prohibits attorneys from being involved in speech that one would consider to be offensive? And we have it here as a 8.4 that's being considered by our Supreme Court here. Are you familiar with that rule, and can you speak to that rule?
I am familiar with it. I'm a critic of it. I think that we've seen these cases develop. I've written about them on our blog for years, that courts are increasingly holding attorneys liable for things that they're saying outside of the courtroom, micromanaging what can be offensive, grotesque political viewpoints, but they are political or religious viewpoints that courts are getting dangerously close to. And so I think it's a mistake Bars are expanding their jurisdiction over speech the way that schools did in the last 10 years of getting further and further out, looking at social media. We just had the cheerleader case, right? That where the court sort of slapped back on that a little bit and ruled for this foul-mouthed cheerleader. But I have a real problem with that. But I also tell you, I have a problem with some of the recent cases as well. I am no fan of Rudy Giuliani. I've criticized him in dozens of columns for years before he became the president's counsel. But I am troubled by aspects of these bar actions against Republican lawyers. There's a campaign that's run out of things like the Lincoln Project, which has been targeting not just Republican lawyers, but their firms, targeting their clients, trying to harass them to drop cases. They've succeeded. I mean, this has been a successful campaign.
Okay. Professor McConnell, are you aware of that, the movement to silence attorneys and through disciplinary rules? And what are your thoughts on those?
I'd like to see the actual language of the rule, but I can't imagine that any rule that uses governmental power to deny someone the right to practice law because somebody thinks it's offensive would get even a single vote on the Supreme Court. That looks like a unanimous case to me. I mean, that's just impossible. Now, maybe there's something in the way the rule is worded that makes it less objectionable than that. And I hate to opine on things when I don't have their language right in front of me.
Since we do have a few more minutes during the course of this webinar, can we talk about basically what, if you had, and I'm going to address this to both of you, if you had the ability to fashion an appropriate response to this issue, how would it be done? And I know, Professor Turley, you've mentioned that we need to look at it as a First Amendment issue versus the way the courts have been looking at it. And so I'll start with you, Professor McConnell. Do you see a way that we started this conversation out to reconcile these rights, these specific rights, especially the right to religious freedom and your beliefs as a private individual and your concerns with being forced to do things which is against your religious beliefs? Is there any way, if you, in a perfect situation, that you would counsel the court address this issue?
When the nature of the speech or religion objection, and I'm actually with Professor Turley that these cases like Masterpiece are better framed as free speech questions, when the objection is that I am being forced to participate in an expressive activity or to speak or use my talents to support something I disagree with, I think the First Amendment, applies. And I just think it was a mistake ever to say that civil rights, it's not that civil rights laws are being cut back. Civil rights laws have never tried. What the civil rights laws are about concrete actions like employment discrimination or denying somebody a house they earn on the basis of who people are. They have never been an attempt to punish people for thought crimes or for speech crimes. And that's I'm sure there's some difficult cases on the margins. There always are. But I do not think that's a hard line in general to draw. We just need to make sure that non-discrimination laws are about discrimination against people because of their identities, rather than using the anti-discrimination laws as basically a cudgel to try to get people like Mr. Phillips to conform to the current thinking of society.
Yeah, I certainly agree. I agree with much of that. One of the concerns that I have in the conflict between anti-discrimination laws and the religion clauses is that the anti-discrimination laws are often treated as per se compelling interests by the state. One of the interesting things about Fulton is that was not entirely clear that the court was willing to just immediately check that box that this is compelling. They were really doing a more nuanced view of the function, looking at the availability of different adoption opportunities and that type of thing. But that creates a rather difficult structure. But the reason I am a big advocate for pushing forward as a free speech matter is that we need it not just for religion, and we're living in the most anti-free speech period in modern history. Indeed, you can go back to the Alien Sedition Acts and the Palmer raids and things like that. There's a difference here. In those previous periods, largely universities were advocates of free speech, and the media was an advocate of free speech. Hollywood was largely an advocate of free speech. That's changed. You now have this perfect storm where free speech is now often treated as the threat to our country, as opposed to the thing that defines us. And that was really captured when President Biden a few days ago said, Facebook is killing people. That really sums up what you hear in a lot of law schools, that free speech is dangerous, it's harmful, and we have to restrict it. And we're raising a generation of censors, and not just on religious but political speech. And that's where I think we have to focus, because if you look in Europe, you'll see what happens, how regulation of speech becomes insatiable as more and more speech is criminalized or curtailed.
Well, again, we've run over our time a little bit here, but I really appreciate both Professors McConnell and Professors Turley for taking time out of your day to enlighten us on this free speech and religious rights and what our courts are doing here today. And just want to thank you and express a lot of aloha for that. We'd also like to thank the Hawaii State Bar Association for hosting us, and also for Kalo TV for promoting us as well. So thank you so much, and I hope to bring you out here someday to have a wonderful seminar, a more lengthy seminar and forum.
I speak for Michael when I speak. We both hope that as well. Yes. Thank you.
Thank you so much. Aloha, folks.
Bye-bye.
Bye-bye.